afternoon, and thank you for joining us for an MP webinar covering the FMLA Mental Health Key 2022 updates. I'm Katie Kreider, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support your organization through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenters for today's program, Sheri Heller and Emily Werlink. Sheri is a SHRM and PHR certified HR partner here at MP. She has over 20 years of experience in employee relations, training and development, strategic planning, and policy development. Sheri earned a Master of Education in Instructional Design from UMass. She spent many years in retail management prior to getting into HR, which provides her with a unique business focus into human resources. Emily is an HR generalist at MP. She provides HR support to small, medium, and large businesses in a variety of industries. She has her BA in Human Resources Management and has worked in the HR field since 2016. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out the recording of the webinar along with the slides later today. And with that, I'm going to hand the mic off to Sheri.
Thanks, Katie, and good afternoon, everybody. We always start with our legal disclaimer because especially today we are going to be talking about employment law. However, this training is intended for educational and informational purposes only. We hope you learn a lot from our session today, but we're not attorneys and nothing we talk about today should be construed as legal advice. All right, that said, let's see. There we go. Our presentation topics today. We'll do an FMLA overview, talk about intermittent FMLA, which when FMLA is due to mental health issues, intermittent FMLA comes into play a little bit more frequently. We'll specifically talk about some of the challenges with FMLA and mental health, and then also how FMLA interacts with state leave laws. We'll finish up with FMLA notice requirements to make sure you're all up to date on that. And then we hope to have enough time at the end to do a live Q&A session, and we've got a resource slide at the end. So with that, let's jump into our first topic. So the FMLA, or the Family Medical Leave Act, went into effect back in 1993. And despite the fact that we've been working with this law for almost 30 years, there are so many nuances to the law that can trip up employers. And then you add to that the uptick in mental health issues that are caused by the pandemic, by isolation of remote work, and numerous other factors. Navigating FMLA can be very tricky for employers. So first, we want to do a quick review of FMLA. All right, so the Family Medical Leave Act provides eligible employees up to 12 work weeks of unpaid leave a year and requires that group health benefits be maintained during the leave as if the employee continued to work instead of taking leave. Employees are also entitled to return to their same or an equivalent job at the end of their leave. So FMLA also provides certain military family leave entitlements. Eligible employees may take FMLA for specified reasons related to certain military deployments of their family members. And additionally, they may take up to 26 weeks of FMLA leave in a single 12-month period to care for a covered service member with a serious injury or illness. So FMLA applies to all public agencies, including local, state, and federal employers and local education agencies or schools. And it also applies to private sector employers who employ 50 or more employees for at least 20 work weeks in the current or preceding calendar year. And this includes joint employers and successors of covered employers. One thing to keep in mind, especially when we're talking about employee counts and who is a covered employer, if you have multiple businesses that are under different Fed IDs, but are all part of the same management group. Let's say, for example, you've got 3 different restaurants, and they all have 3 separate Fed IDs, but at the top, there are common management for those 3 restaurants. The department, even though the IRS looks at those as 3 separate entities, the Department of Labor does not. And Department of Labor is who oversees FMLA. So they would look at that as one entity. So let's say you had 20 employees in each of those locations. Under the IRS regulations, those are still 3 separate entities, but the DOL would look at that as 60 employees under that common management umbrella, and therefore you would be a covered FMLA employer. So who can take FMLA? So in order to be eligible to take leave under the FMLA, an employee must work for a covered employer, have worked at least 1,250 hours during the 12 months prior to the start of the leave, which means it's not just full-timers. It can be part-timers who regularly work, say, 25 or 30 hours a week. They need to work at a location where the employer has 50 or more employees within a 75-mile radius and have worked for the employer for 12 months. And that 12 months of employment is not required to be consecutive in order for the employee to qualify for FMLA. In general, only employment within the last 7 years is counted, unless there's a break in service. So if somebody is a person who comes back seasonally, let's say, and they satisfy the 1,250 hours a year in that 12 months over a few year period, they are likely still covered under an eligible employee under FMLA. So big question we're getting a lot is regarding remote employees. Once COVID hit, so many businesses, MP is one of them, we realized that, wow, remote really works for us. We can open our talent pool, which we have, and we have employees now in about 18 different states. So since many employers have moved to remote work due to the pandemic, there's a lot of questions about whether those remote employees are eligible for FMLA. So under the regulations, remote employees may be eligible for FMLA if they meet the FMLA eligibility requirements, which is being employed with the company for 12 months and working at least 1,250 hours in that 12-month period. And the employer is a covered employer, again, employing 50 or more employees within a 75-mile radius. But according to language in the FMLA regulations, and I'm going to read this because it's very important language, an employee's personal residence is not a work site in the case of, in the case of employees, such as salespersons who travel a sales territory and who generally leave to work and return from work to their personal residence, or employees who work at home under the concept of flexi place or telecommuting. So rather, their work site is the office to which they report and from which assignments are made. So in other words, home offices may not be considered the work location for FMLA purposes. Now, that isn't the same for tax purposes. So somebody who is working remotely from home 100% of the time, they would be covered under that state's laws. But under federal FMLA guidelines, they would not be, their work location is their home residence is not considered their work location for FMLA purposes only. So thus, if the remote worker is reporting to that office, which employs 50 or more employees, and they meet that 12-month and 1,250-hour requirement, the employee will be eligible for FMLA. All right, so under FMLA, there's a number of qualifying conditions. So a covered employer must provide an eligible employee up to 12 work weeks of unpaid job protected leave in a 12-month period for the following reasons. So for the birth of a child, for the placement with the employee of a child for adoption or foster care, to care for an immediate family member, which the regulations define as spouse, child, or parent, but not a parent-in-law with a serious health condition. To take medical leave when the employee is unable to work because of a serious health condition, or for qualifying exigencies, got stuck on the way out, arising out of the fact that the employee's spouse, son, daughter, or parent is on covered active military duty. So the FMLA also allows eligible employees to take up to 26 weeks of unpaid job protected leave in a single 12-month period to care for a covered service member with a serious injury or illness. So how do we define a serious health condition? So the most common serious health conditions that qualify for FMLA are those conditions requiring an overnight stay in a hospital or other medical care facility, conditions that incapacitate you or your family member, for example, being unable to work or attend school for more than 3 consecutive days and have ongoing medical treatment, which includes either multiple appointments with a healthcare provider or a single appointment and follow-up care, such as prescription medication. Also, also chronic conditions that cause occasional periods when the employee or family member are incapacitated and require treatment by a healthcare provider at least 12 times a year. Those are conditions, let's say for chronic migraines, for example, where they pop up occasionally because it's a chronic condition that somebody would likely see a healthcare provider at least twice a year for, and it incapacitates them. It would be possibly considered a serious health condition under FMLA. And then finally, pregnancy, including prenatal medical appointments, incapacity due to morning sickness, and medically required bed rest. All right, so once somebody has requested leave under FMLA, and you've determined, and you're needing to determine whether it's a serious health condition, the employer may require a certification issued by a healthcare provider to support the need for leave for a serious health condition of the employee or the employee's immediate family. The employer must allow the employee at least 15 calendar days to obtain that medical certification. If the employer determines that the certification is incomplete, they must allow the employee a reasonable opportunity to cure the deficiency. So the employer must state in writing what additional information is necessary to make certification complete and sufficient, and must allow the employee at least 7 calendar days to cure the deficiency, unless if 7 days is not practicable under certain circumstances, despite the employee's diligent good faith efforts. So what they mean by that is, let's say that the employee is been contacting their doctor's office, but the doctor's office still hasn't gotten back to them, or maybe their doctor is on vacation and they can't get it. An employer should be flexible in those cases. An employee is not required to give the employer their medical records. The employer, however, does have a statutory right to request that an employee provide medical certification containing sufficient medical facts to establish that a serious health condition exists. So for example, the medical certification may say that the employee is having surgery on a specific date and will be in the hospital for X amount of days, and then will need X amount of days or weeks to recover from the surgery. It doesn't have to specify what the surgery is for. It just has to give you the basics. All right. So can you as an employer contact the employee's healthcare provider about their serious health condition? A lot of times when you get these doctor's notes, it's really not clear what they're saying, and an employer wants to make that call and get some clarification. But the regulations clarify that contact between an employer and an employee's healthcare provider must comply with HIPAA privacy regulations. So under the regulations, employers may contact an employee's healthcare provider for authentication or clarification of the medical certification. And it should be by a healthcare provider, a human resource professional, maybe a leave administrator, or a management official. In order to address the employee privacy concerns, the regulations make it clear that in no case may the employee's direct supervisor contact the employee's healthcare provider. Employers may not ask the healthcare provider for more information beyond what's contained in that medical certification form. So as a condition of restoring an employee who was on FMLA due to their own serious health condition, an employer may have a uniformly applied policy or practice that requires all employees who take leave to submit a certification for the employee from the employee's healthcare provider that the employee is able to resume work. And what's really important in this is that it has to be uniformly applied, meaning you cannot ask for that certification from some employees and not others. Under the regulations, an employer may require that the fitness for duty certification address the employee's ability to perform the essential functions of the position if the employer has appropriately notified the employee that this information will be required and has provided a list of those essential functions, i.e. in a job description. So additionally, an employer may require a fitness for duty certification up to once every 30 days for an employee taking intermittent or reduced schedule FMLA if reasonable safety concerns exist regarding the employee's ability to perform their duties based on that condition that they took leave for. So it gets a little tricky when you are looking for those medical certifications. My best advice to you is to always consult an HR professional or labor attorney just to make sure you're not stepping on any of the regulations. Now, what happens if the employee doesn't submit a requested medical or fitness for duty certification? So if that employee fails to timely submit a properly requested medical certification, absent any sufficient explanation of the delay, again, maybe a doctor being on vacation, FMLA protection for the leave may be delayed or denied if the employee never provides a medical certification. Then the leave is not an FMLA. Then the leave is not an FMLA leave. So yes, you do. If an employee is not being forthcoming with these medical certifications, you can delay approving that leave, or if they don't provide them at all, you can actually deny that leave. If an employee fails to submit a properly requested fitness for duty certification, the employer can delay job restoration until the employee provides the certification. If the employee never provides the certification, they may be denied reinstatement. So again, anytime you are not going to approve a leave or not going to reinstate somebody when they return from leave because of medical certifications, really important again to speak with an HR professional or employment attorney. All right, so with that, I am going to turn the mic over to Emily to talk about intermittent leave.
Thank you, Sheri, and good afternoon, everyone. The next topic we are going to be discussing is intermittent FMLA leave, which, like Sheri said earlier, is a big topic being brought up just due to mental health reasons. So it's important that we cover that today. So one of the most common questions we get asked regarding FMLA is if an employee has to take leave all at once or if it can be taken periodically. And the answer to this question is that when it is medically necessary and under certain circumstances, employees may take FMLA leave intermittently. And what this means is it's just taking leave in separate blocks of time or by reducing the time they work each day or week for a single qualifying reason. So in other words, FMLA does not always have to be taken consecutively. Employees can use intermittent leave for a few different reasons. The first one being their own or qualifying family members' serious health condition. The next one would be covered service members' serious injury or illness. And the next one would be qualifying exigency from a military member's covered active duty status. And something to keep in mind is that in certain cases, such as parental leave, bonding leave, maternity leave, etc., FMLA only permits intermittent leave if the employer agrees. It is not required. It is up to the employer's discretion at that point. And this also may be different under state law. So it is very important to be aware of the laws in the states where your employees work. Another question that is commonly asked is if an employer can change an employee's job when the employee takes intermittent or reduced schedule leave. The answer to this would be that employees needing intermittent or reduced schedule leave for foreseeable medical treatments must work with their employers to schedule the leave so it does not disrupt the employer's regular operations. This is, of course, subject to the approval of the employee's healthcare provider as well. And overall, the employee just should be making a reasonable effort to schedule these treatments outside of their work schedule. In such cases, the employer may transfer the employee temporarily to an alternative job with equivalent pay and benefits that accommodate recurring periods of leave better than the employee's regular job can. Here we have an intermittent leave or intermittent FMLA leave scenario. So an employee named Mary has requested to take FMLA leave for a few half days every other week to care for her chronically sick child who suffers from bipolar disorder. The time off Mary is requesting will be on occasion and mostly for doctor appointments that she must take her child to. Is Mary eligible for intermittent FMLA leave? So is Mary eligible for intermittent FMLA leave? We're going to assume here that she is working for an FMLA covered employee and that she herself is an FMLA covered employee. So if those two things are accurate, then yes, Mary would be eligible for intermittent FMLA leave.
All right, so now let's talk about the topic at hand, which is FMLA and mental health. So according to the CDC, 1 in 5 adults in the US will experience mental illness in a given year, and 1 in 25 adults in the US lives with a serious mental health illness, such as bipolar disorder, schizophrenia, or major depression. The COVID-19 pandemic and the resulting economic pressures on workers have only increased the prevalence of mental health conditions, including anxiety and depression. And just as with physical health conditions, workers struggling with mental health conditions may need to take time away from work to seek treatment or recover. The Department of Labor recently published an updated fact sheet on mental health conditions and the FMLA. So let's take a deeper dive into the FMLA leave for mental health conditions. So as we discussed previously, an eligible employee can take FMLA leave for their own serious health condition or to care for a spouse, child, or parent because of a serious health condition. A serious health condition can include a mental health condition. So mental and physical health conditions are considered serious health conditions under FMLA if they require 1, inpatient care, or 2, continuing treatment by a healthcare provider. A serious mental health condition that requires inpatient care includes an overnight stay in a hospital or other medical care facility, such as, for example, a treatment center for addiction or for eating disorders. A serious mental health condition that requires continuing treatment by a healthcare provider includes conditions that incapacitate an individual for more than 3 consecutive days and require ongoing medical treatment, either multiple appointments with a healthcare provider, including a psychiatrist, clinical psychologist, or clinical social worker, or a single appointment and follow-up care, for example, prescription medication, outpatient rehabilitation counseling, or behavioral therapy. In chronic conditions, for example, anxiety, depression, or dissociative disorder that cause occasional periods when an individual is incapacitated and require treatment by a healthcare provider at least twice a year. So an employer may require an employee to submit a certification from the healthcare provider to support the employee's need for FMLA. The information provided on the certification must be sufficient to support the leave, but a diagnosis is not required. So they don't have to tell you what mental health condition they are suffering from. It just needs to say that they are under a doctor's care for a particular mental health condition that may require them to take time off from work. All right, so reasons for leave, leave for the employee's mental health condition. So an eligible employee can take 12 weeks of leave for their own serious mental health condition that makes the employee unable to perform their essential job duties. So for example, we've got Karen, who occasionally is unable to work due to severe anxiety. She sees a doctor monthly to manage her symptoms. Karen uses FMLA leave to take time off when she's unable to work unexpectedly due to her condition and when she has a regularly scheduled appointment to see her doctor during her work shift. Then there's leave to care for a family member with a mental health condition. So that can be taken to provide for a spouse, child, or parent who's unable to work or perform other regular daily activities because of a serious health condition. Providing care includes providing psychological comfort and reassurance that would be beneficial to a family member with a serious condition who is receiving inpatient or home care. FMLA leave for the care of a child with a serious health condition is generally limited to providing care for a child under the age of 18. So for example, we've got Wyatt, who uses 1 day of FMLA leave to travel to an inpatient facility and attend an aftercare meeting for his 15-year-old son, who has completed 60 days of inpatient drug rehabilitation program. And then we have leave to care for an adult child with mental health conditions. Now, I know I just said that generally that the caring for a child is limited to children under the age of 18, but there are exceptions for mental health conditions. So it might be a parent may use FMLA to care for a child 18 years of age or older who is in need of care because of a serious health condition if the individual is incapable of self-care because of a mental or physical disability. So under FMLA, a disability is a mental or physical impairment that substantially limits one or more major life activities of an individual. To define these terms and determine if the condition is a disability, the FMLA uses the EEOC's regulations under the Americans with Disabilities Act, the ADA. So according to the EEOC, conditions that, in quotes, should easily be concluded, end quote, to be substantially limiting include major depressive disorder, bipolar disorder, post-traumatic stress disorder, obsessive compulsive disorder, and schizophrenia. Conditions that may only be active periodically are considered disabilities if the condition would substantially limit a major life activity when active. So the disability does not have to have occurred or been diagnosed before the age of 18. The disability may start at any age. So there are exceptions to the caring for a child. So for example, we've got Anastasia, who uses FMLA to care for her daughter, Alex. Alex is 24 years old and was recently released from several days of inpatient treatment for mental health condition. She's unable to work or go to school and needs help with cooking, cleaning, shopping, and other daily activities as a result of the condition. In that particular case, Anastasia would be eligible for FMLA leave. And then finally, there's military caregiver leave for mental health conditions. So the FMLA also provides eligible employees with up to 26 weeks of military caregiver leave in a single 12-month period to care for a covered service member and certain veterans with a serious injury or illness. An employee may be an eligible caregiver if they are the spouse, son, daughter, or parent, or next of kin of the service member. So for a current service member, a serious injury or illness is one that was incurred by the service member in the line of duty that may make the service member medically unfit to perform duties of their office, grade, rank, or rating. A serious injury or illness may also result from aggravation in the line of duty on active duty of a condition that existed before the member began service. So for a veteran, a serious injury or illness is one that made the veteran medically unfit to perform their military duties, or an injury or illness that qualifies the veteran for certain benefits from the Department of Veterans Affairs. For veterans, it includes injuries or illnesses that were incurred or aggravated during their military service, but did not manifest until after the veteran left active duty. An injury or illness may manifest after the individual became a veteran. For example, when a military family member has post-traumatic stress disorder, or PTSD, a traumatic brain injury, or depression that occurs well after the event occurred. All right, so question, may I use FMLA when I am unable to work because of severe anxiety? I see a physician monthly for this condition to manage my symptoms. And the answer to that is yes, assuming that you work for a covered employer and are eligible for FMLA leave, you can take leave if you're unable to work due to a serious health condition under FMLA. A chronic condition, whether physical or mental, for example, rheumatoid arthritis, anxiety, or dissociative disorder, that may cause occasional periods when an individual is unable to work, is a qualifying serious health condition if it requires treatment by a healthcare provider at least twice a year and recurs over an extended period of time. All right, next question. I use FMLA once a month for appointments with a mental health therapist. Is my employer required to keep my mental health condition confidential? And the answer to that, again, is yes. The FMLA requires your employer to keep your medical records confidential, and they should be maintained in a separate file from more routine personnel files. Your employer must also maintain your records with confidentiality that's required under other laws, such as the ADA or the Genetic Information Act, where those laws also apply. However, your supervisor and managers may be informed that you need to be away from work, or you may have work restrictions or need accommodations, but they do not need to be informed of your specific medical condition or mental health issue. That popped up again. Let's see, get to the next one. There we go. My son sees a doctor for ADHD. After I used FMLA leave to take my son to behavioral therapy appointments for the condition, my employer sent me an email informing me that I received a negative point on my attendance record. Can my employer punish me for using FMLA? And the answer to that is no. Employers are prohibited for discriminating or retaliating against employees for having exercised or attempting to exercise any FMLA right. So examples include using the taking of FMLA as a negative factor in employment actions, such as in hiring, promotions, or disciplinary actions, or counting FMLA leave against employees in a points-based attendance policy. All right. So with that, I'm going to turn it back over to Emily to talk about FMLA and the interaction with state leave laws.
Thanks, Sheri. So yes, the next topic we will be discussing is FMLA and state laws and how they work together. Many FMLA covered employers do need to consider and determine the various state leave laws that may apply when an employee requests leave under the Family Medical Leave Act. Here are some examples of state leave laws that may apply. There is paid or unpaid family and medical leave, earned sick leave, domestic violence leave, military leave, disability leave, parental or maternity leave, and workers' compensation. Currently, California, Colorado, Connecticut, Delaware, Massachusetts, Maryland, New Jersey, New York, Oregon, Rhode Island, and Washington and the District of Columbia offer paid family and medical leave, which is an addition to the FMLA. This is an important checklist to have when coordinating a leave of absence for an employee. The first step is determining which leave of absence laws apply. Then we will need to determine the eligibility of a particular employee for the particular leave of absence. Then we will assess the reason for the leave of absence. And lastly, it is time to review the company policies, procedures, and practices to make sure we are covering all of our bases and collecting all necessary information to make the right decision for the employee. We have a question here that is commonly asked. What is the total amount of leave the employee may take off? And the answer to that is, in the circumstance that an employee's leave is covered by both state and federal leave laws, the general rule is that the employer must follow the law that gives the employee the greatest benefit or is in the employee's best interest. Employers have the responsibility to apply whichever laws provide the greatest protection to their employees. The next thing we're going to be discussing is concurrent leave. Most leave laws do run concurrently, and this just means that they are simultaneous and are running at the same time. It is extremely important to make sure that we are updating our employee handbooks to state that most leave laws do run concurrently. So for example, in Massachusetts, PFML runs concurrent with FMLA. So this needs to be stated in the handbook to make sure that employees are aware and have acknowledged that. FMLA can also intersect and or run concurrently with numerous obligations set forth in separate but related laws, including but not limited to these listed below: the Americans with Disabilities Act, Workers' Compensation, the Pregnancy Discrimination Act, the Uniformed Services Employment and Reemployment Rights Act, Employee Retirement Income Security Act of 1974, and the Health Insurance Portability and Accountability Act. These are all also other important employment laws to be aware of when assessing an employee's leave of absence. Next slide, Sheri, unless you have something else you want to add.
No, I think I'm there.
Perfect, thank you. Employers may also require employees to substitute their accrued paid leave, such as sick or vacation time, to cover some or all of the FMLA leave. Now, the caveat to this is, for example, PFML in Massachusetts, if an employee uses vacation or sick time, they do not get PFML benefits. So you really do need to know and communicate to all of your employees the specifics depending on what state you are in. Under certain parental leave laws, Massachusetts is also an example that an employer cannot require an employee to use their accrued time off under the parental leave law. So it is very important to comply with all laws and make sure you are in the know as an employer. Here is a visual to help understand concurrent leave and how it works when employee benefits and leave protections may mix. So on the left here, we have income replacement. This could be paid time off, such as sick time or short-term disability, long-term disability, or workers' compensation. And on the right, we have the clock ticking, which is job protected leave and would be FMLA. I really think this visual is helpful to see that if you have an employee who may be out on short-term disability, for example, you want to also designate the employee with job protected FMLA, and this just shows how they really differ.
Right. So a good example of that would be, let's say, when an employee might be out because they maybe they broke their leg in a car accident. They might be eligible for short-term disability, but that may not be considered a serious health condition under FMLA. So it's important to keep in mind that just because somebody was approved for short-term disability doesn't mean they're covered under FMLA, or if somebody is on workers' compensation, you want to make sure that you start that clock ticking for FMLA, because if you don't do them together, what will happen is if that employee comes back from workers' comp, and then they will still be eligible for another 12 weeks of FMLA. So you want to make sure that they're running at the same time.
Yes, thank you, Sheri. And lastly, on this topic, we have a scenario with an employee relating to state leave laws and FMLA. An employee named Amy is struggling with an eating disorder and must stay in the hospital for a 2-week period for treatment. After Amy returns to work, she will then need time off for ongoing therapy appointments. Is Amy eligible for FMLA? So is Amy eligible for FMLA? And similarly to the previous example I did, we are going to assume that she works for an FMLA covered employer and that she is also an FMLA covered employee. So in this case, she would have a block of continuous FMLA for the 2-week hospital stay. And when she returns to work, she will still have 10 weeks of FMLA remaining that she can take intermittently for appointments or whatever treatment she may need.
Okay, so let's talk a little bit about the notice requirements under FMLA. So, excuse me, to meet the general, first off is displaying the FMLA poster in plain view. Excuse me. Secondly is to provide the general notice in the employee handbook. And thirdly, the poster may be posted electronically and general notice may be distributed electronically. In addition to displaying a poster, a covered employer who has eligible employees also must provide that general notice containing the same information. If no handbook or written materials exist, the employer must distribute this general notice to new employees upon hire. So if you have it in your handbook already, that satisfies the general notice requirement. But if you do not have a company handbook or it doesn't have FMLA in there, at hire, you want to provide a new hire with the general notice. The poster can be posted again electronically, and the general notice can be distributed electronically. And may be either oral or in writing, and must be provided within 5 The employee may just say to you, I'm going to have to be out because I have surgery. If you're an FMLA covered employer and that employee meets the eligibility, automatically you need to think, okay, FMLA comes into play here. I need to think about what I have to provide in notices. You want to inform the employee of their rights, of their eligibility status, excuse me. And if the employee is determined to not be eligible for FMLA leave, you want to state at least one reason why. So for example, if the employee hasn't worked enough hours in that year, or hasn't been with the company long enough. The eligibility notice is not required for FMLA absences for the same qualifying reason during the same year. For FMLA absences for a different qualifying reason where the employee's eligibility status hasn't changed. So as long as I'm eligible when I first request FMLA, and let's say I go out for surgery, I'm back in 6 weeks, and then a few months later, I will need to go out again for some additional surgery, you do not have to give me that eligibility notice again. Even if I have to go out for leave for something totally unrelated, maybe I've got to care for a seriously ill child, again, you don't need to give that eligibility notice again. Excuse me, if the employee requests leave for a different qualifying reason in the same year and the employee's eligibility status has changed, important once you have determined that somebody is eligible for FMLA and it's being approved. So each time employers are required to provide the eligibility notice, they also have to provide notice must be in writing and must include, as applicable, notice that the leave may be counted as FMLA, that the employer's designated 12-month period for counting FMLA leave, the employer's designated 12-month period for counting FMLA leave entitlement, any requirements for the employee to furnish a certification and the consequences for failing to do so, information regarding the employee's right or the employer's requirement for substitution of paid leave and conditions relating to any substitution, and the employee's right to take unpaid FMLA leave if conditions for paid leave are not met. It also has to include instructions for making arrangements for any premium payments to maintain health benefits that the employee must make during leave, and potential employee liability if they fail to return to work after FMLA leave.
Sheri, I think there's a little issue with audio. It seems to be cutting off here and there.
Oh, okay. I know I'm getting a message that my internet is unstable. The perils of Zoom. Hello?
I can hear you now.
You can. Okay, great. All right. Let me know if I go out again. All right. It also has to include the employee's right to job restoration and maintenance of benefits. The rights and responsibilities notice may be distributed electronically provided all other requirements are met, and employers can use the form WH-381, which is available at no cost on the Wage and Hour Division's website. And we have on the resource slide, we have the email address, the web address for that. All right. So we did have a couple of questions, a few questions come in. Oh yeah, I'm getting the notes. All right.
Yeah, we got some good questions. Let's see. Do you want me to read them, Sheri, or what's the best way?
So if we have an office with 50 people in Ohio and one person in Nevada working remotely that reports to the Ohio office, that person would be eligible for FMLA if they have 12 months and 1,250 hours. Yes, that is correct. So you would be an FMLA covered employer because you have 50 employees, I'm assuming within a 75-mile radius of your Ohio office, and that individual their home location is not their residence is not considered their work location as far as the DOL is concerned. So yes, that individual, as long as they meet the other requirements, would be eligible for FMLA. All right. We have another really good question here. Let me read this. When an employee is considered for intermittent FMLA after learning there have been ongoing attendance issues, typically FMLA time does not begin until the certification is received back and reviewed. If the prior absences are due to medical condition and the timeline is supported in certification, is it best to backdate and code as FMLA? So one thing about FMLA is you don't want to apply it retroactively. So I think I'm understanding that if somebody has been out off and on, let's say, again, let's talk about, say, chronic migraines or ongoing problems with anxiety or depression, and they've experienced, and you know that this is the reason that they've been out, and you've talked to them about attendance issues, and then they say, I need to take FMLA because I need to get this under control. They're going to be specifically telling you when that FMLA will start. It will not generally be retroactive. And I say generally only because there are times that circumstances happen that somebody is hospitalized and can't apply for FMLA. So it might start when they were first absent, but in general, should not be retroactively applied. So if the employee is applying for FMLA, you get the certification from the doctor and you've approved the FMLA, whatever the start date you determine is when you start the clock ticking, as Emily was saying earlier. You wouldn't backdate it for those previous absences. So I hope that answered that question.
Thank you, Sheri. We got another one here too.
Yeah, I saw that. Yeah. Can you talk again regarding taking FMLA within 12-month period for 2 separate illnesses? Does the same period allowance apply? Oh, I think I understand what you're asking. So it's an eligible employee would be eligible for up to 12 weeks of FMLA in a 12-month period. Now, this depends, and we didn't go into detail because we thought we were going to get in the weeds too much about determining what your FMLA plan or period is. So for most employers, they do it either calendar year or a rolling 12 months or a look back period. So depending on how you determine what your FMLA year is, if I request FMLA, again, let's say I'm going out to have some surgery,
I think you're cutting out again, Sheri.
Am I back? Can you hear me?
Yes, I can hear you now.
Okay. Yep. Sorry about that. So if I took FMLA at the beginning of my FMLA year for, let's say, 6 weeks for surgery, and then a few months later I need to take another 4 weeks for a separate surgery, that would be fine. But after that 6 weeks, I only have 6 weeks left of FMLA in that particular planned year. So I hope that answered that question. All right, so did put together a resource slide. The Department of Labor, as I mentioned earlier, did put out a really great fact sheet on mental health conditions in the FMLA. And then FMLA forms, you can find every form you could possibly need, whether it's your posters, your general notices, everything else on that link. FMLA fact sheets. There is a fact sheet for every question you might have under the sun for FMLA. It's a great site to bookmark. And then there is another site that I find really, really helpful. It's an employment law site or e-law site that is sponsored by the Department of Labor, and it's called the Family and Medical Leave Act Advisor. And you can literally just type in the specifics of the employee and the employer and the leave request, and it will help walk you through whether that person is eligible or not. But again, so important to make sure that even if you are an employee is requesting FMLA, you also have to take into consideration all the other leaves that might be, or employment laws that might apply, whether they be state or local. So with that, I'm going to throw it back to Katie to take us home.
Thanks, Sheri and Emily. We appreciate your time today and lots of valuable information. The MPHR team is here to guide your organization on any HR compliance issues. If you would like to learn more about how we can assist your organization, please visit our website to set up a short 15-minute call. Be sure to join us next week on the same day and time for our webinar on employers and unions, legal advice every organization needs in 2022. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar along with the presentation slides this afternoon. Thanks for joining us and have a terrific day.